Welcome to the Constitution Day Program 2021. On behalf of the WIU Political Science Department and our partners at the Centennial Honors College, I'm Keith Bockelman, Chair of the Political Science Department. I'll introduce our other panelists in a moment, but before I do, I'd like to say a little bit about the origins of Constitution Day. The spark for Constitution Day came from Louise E. Lee, a senior citizen from California. When she was in her 80s, she took a class on the U.S. Constitution offered by a nonprofit organization, the National Center for Constitutional Studies. This course inspired her to found her own nonprofit, National Constitution Day Incorporated, in 1997 at the age of 83. The mission of this organization was to dedicate one day a year to study and honor the Constitution. Ms. Lee convinced the late Senator Robert Byrd to include a Constitution Day amendment to the 2004 Omnibus Spending Bill, which became law in 2005. Under this law, every educational institution receiving federal funding must celebrate the U.S. Constitution each year on or near September 17th. September 17th, 1787 was the date the delegates of the U.S. Constitution approved the document and sent it to the states for ratification. While all educational institutions across the nation must observe Constitution Day or face the prospect of losing federal funding, it is up to each institution to decide the method and scope of their observance. And now, let me introduce our panelists. Tori Smith is a student legal advocate at WIU, a position she accepted in January 2021. Before that, she taught constitutional law in WIU's Political Science Department from 2013 through 2020. Tori is a graduate of both Princeton University and Harvard Law School and is a practicing member of the Illinois Bar. She and her husband, Greg Baldy, a professor of political science at Western, have 3 children. Delilah Sanders is a political science graduate student who completed her undergraduate degree in political science in May of 2021. Her focus as a graduate student is on public administration. She is interested in issues related to community development and government and is a part of the Peace Corps Fellows Program. When she completes her graduate work, she will receive both the MA in political science as well as a post-baccalaureate certificate in community development and economics. She also works at the nonprofit Good Food Collaborative, which addresses food insecurity in McDonough County. So thank you to both of our panelists for appearing today. We're going to start out with Tori Smith, who's going to give us an overview of some of the parts of the Constitution related to the right to vote, and also some of the important court cases that relate to this right. So, Tori, I'll turn it to you.
Thank you, Keith, and thank you for inviting me to participate today about this really timely topic, the right to vote. Voting is arguably our most important civic right because it determines how we're governed, which in turn determines how every other civic right is interpreted and enforced. The Supreme Court has noted that the political franchise of voting is regarded as a fundamental political right because it is preservative of all rights. And the right of suffrage is a fundamental matter in a free and democratic society. You may be surprised to hear, however, that the original Constitution doesn't set parameters about the franchise, but leaves instead those determinations to the states. And when the country was founded, the states reserved voting to a rarefied few. They were all men, they were essentially all white, they had to be 21, they had to be property owners, and even in many cases, they had to be Protestant. And so the promise of we the people, famously the first 3 words of our Constitution's preamble, at least when it comes to voting, didn't initially look anything like what it does today. It wasn't until the 1820s that states began to eliminate property holding requirements for the vote. Religious requirements typically were ended at that same time. It's not until the 15th Amendment, ratified in 1870 after the Civil War, that African Americans are granted the right to vote, and even then, only to men. We've got to wait until 1920, so just over 100 years ago, until women under the 19th Amendment are given the right to vote. 1964, under the 24th Amendment, bans the use of poll taxes in federal elections, and the Supreme Court will join 2 years later and determine that the use of poll taxes in state elections is unconstitutional as well. And it's not until 1971, under the 26th Amendment, that 18-year-olds are given the right to vote. And so about a third, maybe 5 of the 17 non-Bill of Rights amendments have to do with the right to vote and have to do with the ability of Congress to enforce that right. In listing these dates, though, in these amendments, I don't mean to make it sound like the country or the courts were on a steady march towards universal suffrage. In 1875, the Supreme Court is going to hold that women don't have the right to vote, and even though they're citizens, the Constitution has nothing whatsoever to say about that. The following year, in 1876, the Supreme Court is going to rule that Native Americans aren't citizens and therefore aren't entitled to vote. As late as 1959, the Supreme Court is going to uphold literacy tests, even despite their widespread use to suppress minority voting. And in 1974, the Supreme Court is going to uphold as perfectly constitutional denying convicted felons, people who have been convicted of felonies, of the right to vote. And at the same time that we're expanding the franchise through constitutional amendments, there are others, and particularly in places like the former Confederate states, that are working very hard to restrict the vote. And so the 15th Amendment, perhaps the most important of the voting rights amendments, ratified again after the Civil War in 1870, it guarantees the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Southern states like Alabama, Georgia, Louisiana, Mississippi, North Carolina, South Carolina, and Virginia are openly employing tactics like poll taxes and literacy tests and grandfather clauses to make sure that promise, the guarantee of the 15th Amendment, is not enjoyed by African Americans. And so effective is this campaign, both in terms of those tactics and as well with things like Jim Crow laws and campaigns of terror, that the Supreme Court will later describe the first century of congressional enforcement of the 15th Amendment can only be regarded as a failure. So for about 100 years, we see the promise of the 15th Amendment not being realized. But that's going to begin to change with the passage of the Voting Rights Act in 1965. The Voting Rights Act is a federal law. It's passed by Congress under their authority under the 15th Amendment, and it's signed into law by President Lyndon B. Johnson, who will later describe the act as one of the most monumental laws in the entire history of American freedom. Chief Justice Earl Warren later will echo that sentiment in describing the Voting Rights Act as Congress's attempt to banish the blight of racial discrimination in voting, which has infected the electoral process in parts of our country for nearly a century, and to confront an insidious and pervasive evil which had been perpetuated in certain parts of our country through unremitting and ingenious defiance of the Constitution. The Voting Rights Act has a number of sections we'll discuss, I'm sure, today. Section 2, as originally enacted, essentially mirrored the text of the 15th Amendment. And so that section specified that no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color. And so things like the use of literacy tests were banned under that provision. The Voting Rights Act also contained a provision, Section 5, that's referred to as a preclearance provision. And it required that certain jurisdictions receive federal approval before they implement certain kinds of voting laws or procedures. Notably, though, for the case I'm about to describe in a minute, not all jurisdictions were subject to this preclearance requirement. And so the Voting Rights Act also contained something called Section 4B that set up a formula for determining which jurisdictions would be subject to preclearance. And in particular, as originally formulated, that formula looked at which jurisdictions had voting tests in place as of November 1st, 1964. So tests like knowledge tests, good moral character requirements that disproportionately disenfranchised African Americans, and looked also at which of those jurisdictions had less than 50% turnout for the 1964 presidential election. And so that formula, that 4B formula, when the act goes into effect in 1965, sweeps into the pre-clearance requirement places like Alabama, Georgia, Louisiana, Mississippi, South Carolina, and Virginia. There are also later amendments to the act that will sweep in other jurisdictions as well. So why was this pre-clearance important? Well, it provides federal oversight. It provides enforcement of voting rights acts in these places that had made such misuse of things like Jim Crow laws. And so under the pre-clearance provision, these jurisdictions were required to apply either to the Attorney General, who's a federal official, the head official at the Department of Justice, or to a 3-judge panel in a district court in DC to get permission to enact voter laws. And it was incumbent upon those jurisdictions to demonstrate that neither the purpose nor the effect, so intention or result, neither the purpose or effect of denying or abridging the right to vote on account of race or color would be achieved in implementing the voting proposals that they had suggested. And so this pre-clearance system was in place for almost 48 years. And it was very successful. It stopped between the period of 1965 and 2006. There were more than 1,200 voting laws that were stopped in the covered jurisdictions, and studies have suggested that the effect of the pre-clearance process probably stopped a great deal more from being enacted. But this is going to change in 2013. And so in 2013, the Supreme Court is going to hand down a decision in a case called Shelby County v. Holder. Eric Holder was President Obama's Attorney General, the head of the Department of Justice, and Shelby County is a jurisdiction in Alabama that traditionally had been one of the covered jurisdictions under the pre-clearance provision. And so Shelby County files suit in district court, and they seek an injunction. They claim that both the pre-clearance provision of the Voting Rights Act, Section 5, and the formula set forth in Section 4B are unconstitutional. But the district court in that case rules against Shelby County, and the appellate court as well, finding that Congress's reauthorization of those provisions in 2006 are constitutional. And so as originally envisioned, the Voting Rights Act was going to expire after a 5-year period. And so for a number of instances, Congress re-examined the terms of the Voting Rights Act and essentially re-upped. But when they went to re-up in 2006, again, they faced this court challenge that's upheld by both the district court and the appellate court. The Supreme Court tells us not so fast. We receive a decision from Chief Justice John Roberts. It's a split decision, 5-4. Joining him in that vote are what we think of as sort of the traditionally conservative bloc. Then on the court, Justices Antonin Scalia, Anthony Kennedy, Clarence Thomas, and Samuel Alito. And the Shelby County Court will ultimately find that the formula part of the Voting Rights Act, Section 4B, is unconstitutional. Why is that? Well, Chief Justice John Roberts is going to open the opinion. He's going to tell us that Section 5 of the Act, the Voting Rights Act, required states to obtain federal permission before enacting any law related to voting. And he describes that as a drastic departure from basic principles of federalism. And so students from my con law class will tell you that federalism describes the relationship between the federal government and the states. And under the 10th Amendment, all powers not specifically delegated to the federal government belong to the states. So he continues, and Section 4 of the Act applied that requirement only to some states, an equally dramatic departure from the principle that all states enjoy equal sovereignty. This was strong medicine, the Chief Justice tells us, but Congress determined it was needed to address entrenched racial discrimination in voting, an insidious and pervasive evil which had been perpetuated in certain parts of our country through unremitting and ingenious defiance of the Constitution. And he goes on and he says at the same time, voting discrimination still exists. No one doubts that. But he says the question is whether the Act's extraordinary measures, including its disparate treatment of the states, continue to satisfy constitutional requirements. As we put it a short time ago, He tells us the act imposes current burdens and must be justified by current needs. And the Chief Justice goes on to acknowledge that the Voting Rights Act had been immensely successful at redressing racial discrimination and integrating the voting process. But he noted that, quote, regardless of how to look at the record, and it was a lengthy record because Congress had really taken very seriously its obligation to investigate this issue. Regardless of how to look at the record, no one can fairly say that it shows anything approaching the pervasive, flagrant, widespread, and rampant discrimination that faced Congress in 1965 and that clearly distinguished the covered jurisdictions from the rest of the nation. And so he concluded that the present conditions on the ground today in 2013 do not warrant the extraordinary departure from the traditional course of relations between the states and the federal government. The Chief Justice concluded that our country has changed, and while any racial discrimination in voting is too much, Congress must ensure that the legislation it passes to remedy that problem speaks to current conditions. And so a formula, he said, that relied on data that was more than 40 years old could not satisfy that requirement. We have a dissent, and we frequently in these voting rights cases see these same justices lining up on this side. The dissent is authored by Justice Ruth Bader Ginsburg. She's joined by Justices Stephen Breyer, Sonia Sotomayor, and Elena Kagan. And she objects to the idea that Congress doesn't have the authority under the 14th and 15th Amendment to enact or to reauthorize such legislation. She tells us that the grand aim of the Voting Rights Act is to secure to all in our polity equal citizenship stature, a voice in our democracy undiluted by race. And so dilution of the vote is going to be a big issue that we're going to see. As a record for the 2006 reauthorization makes abundantly clear, second-generation barriers to minority voting rights have emerged in the covered jurisdictions as attempted substitutes for the first-generation barriers that originally triggered preclearance in those jurisdictions. And so this is an idea she talks a lot about. A first-generation barrier is like a literacy test that says if you can't read to the satisfaction of the poll worker, you can't vote. But if you're white and your grandfather could vote before the Civil War, then you're exempted from that clause. And she tells us that these second generation barriers are, again, things like the dilution of votes and making sure that, for instance, the votes of racial minorities don't count in the same way because of the way we draw legislative districts. And so she continues, in truth, the evolution of voting discrimination into more subtle second generation barriers is powerful evidence that a remedy as effective as preclearance remains vital to protect minority voting rights and prevent backsliding. And then she gives us a really great line. I love how powerful this is. She says, throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. I think it's worth noting that nothing about this decision, the Shelby County decision, says anything about the constitutionality of the preclearance process itself. Justice Clarence Thomas writes a concurrence, and he thinks it's unconstitutional, but Chief Justice John Roberts is really careful to say that the decision in Shelby County, quote, in no way affects the permanent nationwide ban on racial discrimination in voting found in Section 2. But the practical effect of the Shelby County decision is that jurisdictions that for more than 40 years had been forced to get federal approval to change their voting laws suddenly were free to do whatever they wanted. And I think Delilah in a moment is going to tell you they really have done that, in fact. But so I'm going to turn now the camera over to Dr. Bockelman, who's going to tell us a little bit about whether that promise that Chief Justice John Roberts tells us in Shelby County about the efficacy of Section 2 remains valid today.
Well, so I won't give away the answer immediately, but thank you for that that interesting and very enlightening discussion. So to kind of follow up on what Tori talked about, I'm going to talk about a subsequent Supreme Court decision, Brenovich versus DNC, which is really the most recent landmark case at least, dealing with voting rights. And so this case was argued in 2020 and then decided just this year in 2021. As Tori sort of indicated, it is another voting rights case, which also follows out of the purview of the 15th Amendment. This one is more focused on Section 2, which she had also mentioned. And generally, Section 2, again, prohibits state and local governments from imposing a law that discriminates against a racial or language minority. So a racial group or a group that speaks non-English. Section 2 prohibits discrimination in voting against these groups. This prohibition can be either intentional or results-based. So in other words, if the restriction is intentional, it's illegal, and it also violates the 15th Amendment, of course. But it also doesn't have to be intentional. If the results of the discrimination are affecting a minority, racial, or language group, then that's also illegal, according to Section 2. So the Brenovich case involved a couple of restrictions in Arizona law that were viewed as harming minority voters. One of these restrictions put limits on so-called ballot harvesting by most people, including political activists and campaign workers. Ballot harvesting essentially entails collecting a bunch of ballots and then turning them over to an election authority. So there are some groups that are still allowed to do this, like family members, election officials, caregivers, but it eliminated many of the previous uses of ballot harvesting. Ballot harvesting in Arizona is particularly viewed as beneficial to Native Americans who often live a long distance from mailboxes, and so they often find it harder to deliver their ballots by mail, and so ballot harvesting helps them vote. The other restriction involved votes cast at the wrong precinct. So under the Arizona law, if you cast your vote at the wrong precinct, then your vote wouldn't count. So for example, here in Macomb, I voted Maple Avenue Christian Church. If somehow, because I spaced out and went over to the Wesley Church and cast my ballot, which is another polling place which many students use, then under Arizona law, my vote wouldn't count because I went to the wrong place. This provision was also seen as discriminatory. African Americans and Hispanics were seen as disproportionately being affected by this law, that they were more likely to have their votes not counted because of this. I would also say that Arizona is 11 times more likely than any other state to discard votes for people voting at the wrong precinct. So there's that. So the question was, is this law constitutional under Section 2? By a 6-3 vote, the Supreme Court upheld the law. And I want to talk a little bit about what Justice Samuel Alito talked about in his majority opinion, laying out the reasoning why he thought this law, and the majority thought this law was constitutional. So Alito, in his opinion, laid out several so-called circumstances to consider when evaluating laws under Section 2. The first one he identified was the burden imposed by the voting rule. So did this law impose a serious burden on voting, or was it more limited? In the opinion he wrote, every voting rule imposes a burden of some sort. Mere inconvenience cannot be enough to demonstrate a violation of Section 2. Secondly, the courts need to consider the extent to which the voting rule being challenged differs from practice in place in 1982. And that was when the Voting Rights Act was updated. So in 1982, most states required people to vote in person on Election Day, and only very narrow categories of voters were allowed to permit no excuse absentee votes. In fact, Alito observed that only 3 states permitted this practice in 1982, in the early 1980s, I should say. Third factor he looked at was the size, the disparate impact. So he argued that just because a voting practice had a disparate impact on minority voters does not mean that they don't have an equal opportunity to vote in other ways. So he said, quote, "The size of the disparity matters, and any comparison should be, quote unquote, meaningful. What at the bottom are very small differences should not be artificially magnified," he wrote. The fourth factor the courts should consider, Alito argued, was the context of the state's entire voting system and whether or not they provided other opportunities for voters to vote. He wrote, "Where a state provides multiple opportunities to vote, any burden imposed on voters who choose one of the available options cannot be evaluated without also taking into account the other available means." So in other words, does the state provide a lot of ways to vote, or is it just a few? And that's something that should be taken into consideration in determining whether a law is valid or not. So Alito argued that Arizona made it relatively easy to vote. It allows in-person or mail-in balloting a month before Election Day, and so therefore he felt that this gave people many opportunities to vote, and therefore the law was okay. And then fifth and finally, Alito argued that the court should look at the reasons why states wanted to impose a particular voting rule. So here he said you need to balance access on the one hand versus concerns such as voter fraud on the other. So these criteria that he lays out, I think in some, make it more difficult in future cases for voters arguing that a voter law violates Section 2. So Delilah, again, is going to talk about some specific instances of state laws in a little bit, but I think this decision, in effect, makes it harder for states to, or excuse me, for the Supreme Court or the lower courts to overrule such laws, and some of the ones that she's going to talk about. So in sum, Alito's opinion argues the touchstone of Section 2 is the requirement that voting be equally open, and the DNC, the plaintiff in this case, just couldn't make the case that voting is not equally open to all of the residents of Arizona, regardless of their race or their language status. In her dissenting opinion, Justice Elena Kagan basically argued the majority was kind of making stuff up when they were putting these criteria into place. Instead, she argued the intent of Section 2 is to treat every voter equally, and she argued the majority undermines Section 2 and the rights it provide. Somewhat acidly, she called the majority opinion a, quote, law-free zone. Kagan noted that Section 2 is supposed to be a backup plan rather than the primary mechanism to ensure that voting rights are protected. So Tori mentioned earlier Section 5 of the Voting Rights Act. She saw that as the main enforcement mechanism, but since Shelby versus Holder, there's really no plan B, C, or D for protecting voting rights. Section 2 is all that voters have left. And it's the only basis now for striking down discriminatory laws. More broadly, critics charge that Alito essentially threw out the results test in the statute and paved the way for the Supreme Court to uphold state laws restricting the vote that are currently being passed or under consideration, which again, Delilah will talk about in a little bit. So the significance of this is a lot harder to prove a law has discriminatory intent than it has discriminatory results. And so the short story here, which Delilah is going to give us the longer story, but the short story here is that some of these laws that are being passed that restrict voting, while ostensibly race neutral, have the result of making it harder for minority groups to vote. I mean, as an example, and Delilah may talk about these, but cutting Sunday absentee voting, which sometimes favors African American voters. So even though the results may have a disparate impact, this decision makes it harder to use the Voting Rights Act to strike these down. So to kind of summarize, the opposition to this decision is arguing the whole point of the Voting Rights Act and the 15th Amendment, which it enforces, was to redress a long history of state-sponsored discrimination that treated citizens of color as second-class citizens, denying them the right to vote. The 15th Amendment transformed the Constitution, but wasn't really fully realized until the Voting Rights Act. This decision, critics say, turns both the Constitution and the Voting Rights Act on their head. So now I'm going to turn it over to Delilah, and she's going to talk a little bit about what's going on in the states and also implications of what Congress might do in terms of current laws on voting, and then she's going to raise a few questions for us to discuss at the end about what the future might hold. So, Delilah?
Yes. So there's been a lot of publicity about new restrictive state voting laws. So between January 1st and July 14th of 2021, at least 18 states have enacted 30 laws that restrict the vote. So, for example, we have, in Texas, they passed a law that at the end of August, it makes it harder to vote, especially in urban areas. The legislation forbids balloting methods that Harris County, the state's largest county, which includes like the city of Houston, introduced last year to make voting easier during the pandemic, including drive-through polling places and 24-hour voting, as well as temporary voting locations. It also bars election officials from sending voters unsolicited absentee ballot applications and from promoting the use of vote by mail, which was kind of a hot topic, especially in the 2020 election. So that was something that is kind of important to discuss. The Texas bill greatly empowers partisan poll watchers, which creates new criminal and civil penalties for poll workers and erects new barriers for those looking to help voters who need assistance, such as with translations, which would directly affect our immigrant population, especially our Spanish-speaking population. It also requires large Texas counties where Democrats tend to perform better to provide live streaming video at ballot counting locations. I think this is in direct response to the contention that we had in the 2020 election as well, presidential election. More broadly, there are I'll touch on some of the more like common restrictive laws that have recently been passed. So it expanded voter purges. That was 7 states. So this means like clearing out voter rolls, but sometimes expunges eligible voters. Shortening the window to apply for a mail-in ballot. 6 states did this, which is, like I said, we saw a lot about the mail-in ballot with the COVID-19 pandemic and the 2020 election last year. So that was absolutely substantial. We also have restricting assistance in returning a mail-in ballot. So Dr. Bockelman talked about ballot harvesting. 6 states decided to do that. And then we also have shortening the window to apply for a mail-in ballot, which I know I would have definitely been affected by that because I did a mail-in ballot. So these are things that would all definitely affect certain people and certain groups as well. Tougher voter ID requirements, like this would be things like limiting what kinds of IDs can be used, like, driver's license or what kind of form of identification can be used. Limiting the location availability of ballot drop boxes in 4 states. This is absolutely substantial. If you are someplace where you cannot get to a ballot box, that could absolutely make a difference, especially from those with low-income households, and they maybe take public transportation and things like that. So these are very, very restrictive. Also, another one that I didn't really think of, but there are also 3 states decided to eliminate or limit sending ballot application to voters who do not specifically request them. So if you don't specifically go out of your way to request a ballot application, you don't get one, as opposed to it just showing up in your mailbox and you're like, oh, I need to vote. So although we have talked a little bit about laws, kind of restricting it, there actually have been more laws kind of expanding it in a sense. So, for example, while 2 states limited early voting, 8 states expanded it. So Montana, for example, ended election day registration. Nevada and Hawaii expanded it. So also, while 3 states made it harder for disabled people to vote, 10 states made it easier. This doesn't apply to everything. For example, more states impose tougher ID requirements than easy ones, but it's not all bad news. At the congressional level, we have the John Lewis Voting Rights Act, which restored the Justice Department's ability to deny voting changes in states that have had a history of discrimination or deny certain types of voting rules changes, such as requiring different types of voter ID. So it could mitigate the effects of Shelby versus Holder and the Brenovich cases that we were talking about. This bill passed the House in August, but it faces uncertain at best prospects in the Senate, and it is unlikely to get the 60 votes needed to overcome a filibuster. Broader legislation, known as the Four People Act, would have mandated same-day registration and early voting, but we have to see. So, we've had more than 900 bills with expansive provisions have been introduced in 49 states in the 2021 legislative sessions. So we have to wait and see how they pan out in the Senate. But it's important to realize that there are some things that are going on with restrictive voting and how it will disproportionately affect minority communities, low-income communities, and how with expansive expensive voting laws, we can reach more people. And I think that's important to think about, and we need to keep a look on what's going on. So with that, I have a couple of questions. So this is for Tori. We're going to start with Tori. So what do you anticipate in terms of upcoming Supreme Court cases on voting rights? Do you see further blockbuster cases on like Shelby County or Brenovich, or is the Supreme Court more likely to avoid this issue in the coming years?
Well, I think, Delilah, as I was listening to you talk, it occurs to me that in the same way that the country is very divided right now, kind of split along partisan lines, the voting issue is no different. And so I think Republicans would tell you that what's going on at the state level is an effort to ensure the integrity of voting. I think that they would say that there were problems in the 2020 election, and so they're just putting into place common sense measures to avoid fraud. And there are tons of governors who have quotes to that effect at the state level. I think the opponents of these laws will say that they disproportionately impact and disenfranchise Black and brown voters, and that it's critically important, especially in light of this notion of first generation and second generation bars to voting participation, to be sensitive to that. And so you have a completely different narrative on two sides about what's happening with something as simple as Dr. Bachman described, something like a voting out of precinct law or a voting collection law. The Supreme Court, I think, is getting out of the game. I think that they have signaled in lots of different ways that this is they no longer see themselves as protecting anything other than the most flagrant infringements on minority voting rights. And so we see that they, in a 2019 case called Rucho v. Common Cause, they say with respect to partisan gerrymandering, and so partisan is when, for instance, in North Carolina, you have to redraw your congressional lines after every census. And so North Carolina redraws its lines, and typically in North Carolina, the Democrats and the Republicans are split about 50-50. And so the Republicans in that state redraw congressional lines in such a way that they receive something like 53% of the statewide vote, and they get 10 out of 13 congressional states with that 53%. Not just Republicans in Maryland, the Democrats are doing the same thing. In Illinois, Republicans have accused Democrats of doing the same thing. But in the 2019 Rucho decision, the Supreme Court says, you know what, we don't have the authority to fix this. That this is what we call in constitutional law a political question. A political question is one that's beyond the reach of federal courts because it's committed to another institution. And so in the instance of gerrymandering and redistricting, it belongs to state legislatures with oversight by Congress. But the Supreme Court tells us that they have no role in that. And so they're taking a step back and not reviewing these what they acknowledge seem like very unjust violations. I think it was really interesting when Dr. Bachman was talking about Justice Alito itemizes a number of factors in the Brenovich decision that he said you need to look at when you're evaluating what he called time, place, manner restrictions on voting, no Sunday voting, no overnight drop-off boxes. And of those 5 that Dr. Bachman mentioned, there's no consideration of the impact on minority groups. There's no consideration of whether minority groups have suffered discrimination in the past and whether the effects of that discrimination continue to this day. And in fact, he says to us about both of those criteria that they're less directly relevant. So he's not interested. He accepts this history, right, that the dissent, and so Justice Sotomayor will go through, Justice Ruth Bader Ginsburg will go through these long dissents of the really shameful past that we have as a country. And I'll say, but that was the past. And so we see the Supreme Court kind of stepping back. They have two other decisions in 2018. There was a decision called Abbott v. Perez, Abbott being the governor of Texas, and Justice Alito, who's written a number of these decisions, tells us in the Abbott v. Perez case that legislatures are entitled to a presumption of good faith when being challenged about whether they enact a law with discriminatory intent, a presumption of good faith. And so you as a litigant have got to demonstrate that they didn't have good faith. And he says additionally that evidence of past discrimination can't overcome that presumption of good faith. And so we're looking at making it essentially very, very, very hard to prove something like this at a time when it has been thrown back to voters. So when we had the regime of preclearance, it wasn't up to individual voters to vindicate rights. And there was a recognition, and Justice Ginsburg writes about this quite a bit, that part of the enactment of the Voting Rights Act was Congress's recognition that this kind of whack-a-mole, she says whack-a-mole approach to voting limitations in the past hadn't really worked because they're cumbersome, they're onerous, they're very expensive, they're not timely. And so the pre-clearance was an attempt to get around that. And we're kind of back to the whack-a-mole. And so finally, there was another 2018 Supreme Court decision, again, authored by Justice Alito, also 5-4. Many of these decisions are breaking down along ideological lines. And in that decision, they uphold an effort by Ohio to purge its voter rolls. And in that context, Justice Sonia Sotomayor, you get the sense, is getting increasingly frustrated with these decisions. She writes a separate dissent, and she takes the majority in that case to task. This is Houston v. A. Philip Randolph Institute. She takes them to task for ignoring, quote, the long history of such list cleansing mechanisms which have been used to violate the basic rights of citizens, particularly low-income and minority citizens. And she concludes her dissent with what I read as a warning, right? She says, communities that are disproportionately affected by unnecessarily harsh registration laws should not tolerate efforts to marginalize their influence in the political process, nor should allies who recognize blatant unfairness stand idly by. Today's decision forces these communities and their allies to be even more proactive and vigilant in holding their states accountable and working to dismantle the obstacles they face in exercising the fundamental right to vote. That's a holy cow. That's her saying, we're not here. The Supreme Court is not coming to your aid anymore on these issues. And so So the short answer is I don't expect additional big decisions from the court on these issues.
Thank you. So I kind of touched on this a little bit about like the 2020 presidential election, and how contentious that was, and especially when it came to, voting and what was actually right and what actually happened. So this is for Dr. Bockelman. What do you think will be the political fallout from the state changes in these voting rules?
Okay, well, thank you for that question. And before I answer that, I rarely laugh when discussing constitutional law, but this idea of the good faith assumption for state legislatures, it did make me laugh a little bit. So thank you for that one. But in terms of the political impact, I think you're exactly right to sort of tie this to the 2020 election. I think the political impact of this is really stemming from the controversy surrounding the 2020 election and so forth. Let me say a couple of things. A lot of political scientists have made the argument that these voting restrictions don't really have that much of an impact. And the reason they say that is in part because people see their right to vote being restricted and they get angry. And so they make all the more effort to try to go out and vote. I'm a little skeptical of that argument, not because that hasn't happened, it clearly has, but I wonder about the long-term impact. Are people going to stay angry for election after election after election? Another argument people sometimes make is, well, this is really only going to affect a few voters. But I think if we looked at the last election, the 2020 presidential election, you saw a lot of states where the election was very close. So I don't really buy that argument as well, or much as well. So I don't think we can be too sanguine about this and say, it's really not going to have a political impact. I think this is an instance where political science are kind of losing the forest for the trees. And I worry about the long-term political impact of this. I think clearly the right to vote is precious and it's something that we should allow every citizen, not only allow, but encourage every citizen to do. And I think these voting laws that you described often don't do that very well. I guess I would reiterate what Tori said about the red and blue states. I think your discussion, Delilah, really brought that out. It's really the red states that are restricting voting by and large. And the blue states are enabling voting. And so there's two things going on. I think both of these are happening. I thought, that was interesting the way you kind of laid that out and that both are doing this. I guess the one other thing I would say in terms of political impact that's maybe a little bit more off the radar but shouldn't be is states that are playing around with the idea of taking electoral college votes completely out of the hands of the voters and allowing state legislatures to do that. I don't think we paid enough attention to that, and I think that's even more dangerous than some of these other voting laws that we're talking about. So that idea makes me very nervous, and I think that's something that could clearly affect presidential elections in the future. But thank you again for the question. So I think we're going to wrap it up there. Thank you to both of our panelists for their excellent discussion of various facets of this issue. And I appreciate University TV for allowing us to film this. So thank you again.